Selamat pagi. To the number of
So thank you very much, Professor Bayu, for your introduction. And hello, everyone. Good morning from Groningen. Good afternoon, I think, in Indonesia. Our team is very happy to hold this session. And there are some changes in the presentation list because it appears that it's easier for Siti to present first. So for our session, Siti will present first, and then followed by Marlis, and then I will close the presentation with my presentation. Before we begin, I would like to introduce our speakers. The first is Siti Ruhama. So Siti is an assistant professor of Universitas Islam Indonesia, and she is currently a PhD candidate in the Department of Administrative Law in the Faculty of Law, University of Groningen. And then our second presenter is Dr. Marlis Hazelman. She is a dear colleague of mine. We come from the same department, the Transboundary Legal Studies department. And she will present her research about climate litigation comparing Indonesia and the Netherlands. And then I myself, my name is Ratna Juwita. I am an assistant professor of Universitas Atmajaya Yogyakarta, and I also visiting research fellow in the Department of Transboundary Legal Studies. I will explain how corruption hampers the realization of the right to a healthy environment. So without further ado, I would like to give the floor to Siti. Siti, the time is yours.
Okay, thank you, Ratna. Okay. Good morning in Netherlands and good afternoon in Indonesia. My name is Siti Ruhama Madatilah, and I would like to present about achieving the right to a healthy environment in Indonesia through climate change litigation. Could you please next to my slide? Okay, and I believe that all of us agree with that. Proper health is one of the basic human rights, and proper health indeed requires a healthy environment. Okay, next, please. So this is I would like to introduce you what is actually climate litigation. So this is a brief picture of the climate litigation. Then there is a plaintiff. Plaintiff is a group of people or an individual or even a body, but they suffered from a governmental policy or governmental action or inaction, and instead of there are directly protest to the government, they choose to go to the court and ask the court to compel the government to adjust their policy or to revise their policy to be more sustainable or to be more adaptive to climate change. And this is that we call it as litigation. Litigation means that you choose the court procedure to compel someone or to make some decision on your problems. And in this case, I only focus on the government, but because sometimes climate litigation could be also against the corporations. But in this matter, I only focus to the government. Okay, next, please. And this is the theoretical meaning of the climate litigation, theoretical definition that is encompassing any lawsuit brought before administrative, investigatory, or judicial bodies that touches on issue of law or fact regarding climate change mitigation and adaptation effort. Okay, next, please. So this is also classification litigation that we can call as climate litigation, because the fact is the litigation that we can call as climate litigation is not merely put the climate change as the central issue or central best the central claim of the lawsuit, but it could be many other environmental problems, but has indirect linked to the climate change issue. But in this matter, I only will focus on the climate change litigation in Indonesia. But there are also climate litigation in other countries, of course, and litigation with climate change as the central issue usually we found in the cases of climate litigation in the developed country, in the European countries, in the US, or in Australia. They put climate change as a central issue. They mention climate change as the basis of their claim, and they ask the government to increase their emission reduction target, for example. But in Indonesia, our climate litigation is in the second or third layer, or even the fourth layer. I mean that there is many other environmental issues like air pollution, for example, or peatland fires, or coal mining permission, or coal power plants operation, but they didn't mention specifically climate change. But they also didn't recognize that they claim also have impact to the climate mitigation. And this is I will emphasize that Indonesia have the climate change litigation as the peripheral issue, climate change as the peripheral issue, not as the central issue like in the developed countries. Okay, next, please. So I will start with case by case, and I will start firstly with the climate change litigation before administrative court. This is some efforts taken by the people to compel the government decision for the some permission to coal power plants. Next, please. Okay, there are two successful cases in Indonesia. There's a cancellation of governmental permits on the establishment of some coal power plants. We know exactly that now we still huge rely on the coal as our energy sources, and the government still keep establishing new power plants in Indonesia. But the people who have some awareness about this issue, they try to challenge this government decision and brought it to before the administrative court, ask for the cancellation of the permission, and it is successful, such as in the case of the Tanjung Jati A power plant in 2016. The reason is they want to cancel the government permission because the government missed or didn't taken into account the emission produced from that power plants. So because of this reason, they go to the administrative court, and the administrative court finally in favor with the plaintiffs and decide to cancel or declare that the governmental permission on this power plant was unlawful. And the second case is the power plant Cirebon 2 in 2017. There are also requests for cancellation to the power plant, but the reason is not because of the climate change. The reason is that the establishment of this power plant was not in line with the spatial planning of that region. So this is the I called as climate change as the peripheral issue. But in the first case, climate change could be considered as the central issue. The next, please. Okay, but we also have to realize that not all the cases uh, brought before court are successful. It is the example of unsuccessful case. This is the failed claim before administrative court again to ask for cancellations of the coal power plant permission, but uh, the first instance court and until the Supreme Court consistently in favor with the defendant means that the court declared that the permission was legal. And if I read from many newspaper or online website newspaper also, there are intergenerational injustice issue come up because of this power plant. Uh, we recognize, we understand that this is the public necessity to fulfill the necessity of the energy sources that we still rely hugely on power plant, but we also forget that there is a certain group of people that feel disadvantage about this power plant. For example, a farmer who live around the power plant feels that reduction on their production, for example, or fishermen also feels that there's no such many fish that they can harvest from the environment because of the impact this coal power plant operation because of the pollution, for example. So this is create some intergenerational injustice that we have to aware about this. Okay, the next, please. And this is another case of climate litigation. The three cases is before the administrative court, but this is the cases that we see in the civil court that how climate litigation provokes policy change. The next, please. Okay, the first is about the air pollution in Jakarta. It is brought by some Jakarta residents. We know Melanie Subono is a celebrity in Indonesia, and Melanie Subono and other Jakarta residents try to influence the Indonesian government at the time because of the severe air pollution in Jakarta in 2019. They mentioned from the president until the provincial government of Jakarta to adjust their policy, to adjust their regulation to be more sustainable or to be more adaptive to the pollution in Jakarta. There are two main concern in this case. The first is that provincial government of Jakarta should uh, do some regular emission testing from vehicle because it is scientifically proved that pollution in Jakarta mainly because of the fossil fuel used for transportation. And I did an interview last month with the Jakarta province that they already did the best. They already increased regulation about the emission testing for the vehicles, or even they already implemented the punishment, administrative punishment for the owner of vehicle who didn't take the emission testing for their vehicle. So this is the good news. But there is also the second concern that the provincial government should increase their environment air quality standard in that city. But I found that there is no increase that is created by the provincial government because the reason is that they just follow the air quality standard set by the central government, which is the Ministry of Environment and Forestry. But based on regulation, the local government doesn't need to wait for central government policy to increase their air quality standard. Uh, but again, it is understandable why local government like provincial government of Jakarta didn't increase, because once the government increased the air quality standard means that many other governmental sector will influenced, such as uh, the government should provide more greener energy. For example, the government should provide more green spaces in that city, or they have to limit the fossil fuel based transportation, for example. I understand this. It is not easy way to just increase the air quality standard, but still our concern that there is the court rulings that is not well implemented by the government. Okay, we move to other case to another case, please. Okay, this is the Ari Rompas versus Indonesia. If you remember about the huge catastrophic of the peatland fires in 2015, and causing a huge smoke haze pollution in Kalimantan and Sumatra. This also led a, a climate litigation before the civil court, uh, work by Ari Rompas and resident of Palangkaraya, and also Walhi, an NGO, environmental NGO in Indonesia, against the Indonesian government, start from the president until the provincial government of Central Kalimantan. Uh, it is also considered successful case. And I also did an interview with the provincial government of Central Kalimantan. They say that this is a good case, even though they are act as a defendant, but they take it as the trigger for them to achieve their goal even faster, because they claim that what the plaintiff requests is already in line with their goal actually, but we at that time we they had not even achieved to that goal, but because of this claim, it triggered they program or their action to their goal. uh, okay, the next please. So this is also another climate litigation, but it is quite different because the plaintiffs is the Indonesian government. It means that the Ministry of Environment and Forestry against the corporations as the perpetrator of, mainly of them are plantation corporation, because of the environmental degradation. So the government should the corporation to pay some punitive damage or compensation for environmental rehabilitation. I will give you a successful example, but actually there are a lot. Okay, the next please. So this is the example of the climate litigation shoot by the government against corporation, and there is court decisions that in favor with the government, in favor with the plaintiff, then declare that the corporation should pay some amount of money to the government, and the government will use the money for environmental conservation or environmental recovery. But we face another challenge because the court decision was good, of course, but we have another challenge, which is the enforcement. How the court can enforce the corporation to pay this penalty, because we know that corporation is independent legal subject. They can just ask they can just act insolvency if the asset cannot pay such amount of money. So they just ask so the government or the court cannot access further to their asset, because again they can claim as they are insolvent for this case. Next please. Yeah, and this is also the same case, another case, which is the government act as a plaintiff and the corporation as a defendant. The next please. Yeah, so this is my conclusion and also my recommendation. So from those cases, what do the Indonesian climate change litigation mean? Next please. So I conclude and make some these three recommendation. First is that our judge or our judicative institutions is already quite progressive. I mean that they already many ruling that they made in favor with the environmental conservation. Um, uh, they stand with environment conservation means that also they in favor with the public in a whole. They are in favor with the ecosystem, with another creators like plants and animal, or even they also stand with the future generation. But I still have some improvement recommendation that we can still increase the capacity of our environmental judge and their understanding to the complex issue like climate change, because climate change is very complex issue. There include the future generation, there include the transboundary impact, yeah, to other countries, for example. So we need to improve our judge capacity in this case. And the second is climate change litigation in Indonesia is still sporadic and right-based litigation. It's good right-based litigation, but it's still sporadic. I mean that we can make some improvement to make this climb more integrated to one and another, and addressing more strategic policy. I mean that as we see that we just claim the government or sue the government in the separated cases, air pollution, peatland fire, or coal power plant establishment, but how we try to make it integrated and addressing more strategic policy. Like, okay, maybe Marilis will talk more about the climate litigation in developed country or in the Netherlands, for example. And the third recommendation is we should use, yeah, this is always forget that our government is already have commitment to reduce emission to the global community that we call it as nationally determined contribution. And our government already increased their commitment to reduce the policy to be 31.89% by 2030, and it without international assistance. But with international assistance, they try to achieve more to be 43.20% by 2030. I mean that this is commitment that the government submit to international community. We have to use and to remind our government that you have commitment. And why do we put this the governmental commitment to evaluate or to revise whether any governmental regulation or policy that is not in line with their commitment. So please help our government to synchronize its policy to their NDC and its commitment to the energy transition. I think that's all for me, because we still have two other distinguished speaker. And thank you so much, and have a good day for all of us. Thank you.
Yes, thank you very much for your comprehensive presentation, Titi. And Titi's presentation will be perfectly followed by Marli's presentation. She will compare the practices in the Netherlands with the practices in Indonesia with regard to climate change litigation. Time is yours, Marlis.
Thank you, Ratna. Oh, thanks. Thank you, Ratna, and also many thanks to the people of Winner for the expert organization of this conference. I'm really enjoying to be part of it and to have a chance to tell a little bit about my research, but to also, through it, explore opportunities for further cooperation in this area. So today, I want to say a little bit more about rights-based climate change litigation and comparing a little bit what is happening in this front in the Netherlands and in Indonesia. This topic fits in with the wider research interest that I have in the intersections between human rights and environment, climate change, energy, and also with a focus on the effects of climate change on environmental health as part of our Groningen Center for Health Law. My aim is to narrow down a little bit into these two countries, but I thought it would be good to start by acknowledging that climate change litigation is really part of a global trend. There are cases now popping up in many different parts of the world, both in the global north and in the global south, including both in Indonesia and the Netherlands. And what you see here on your left is a list of countries where we now know that climate change litigation in one form or shape has taken place. This is a list that you can find on the so-called climate case chart, which is run by Columbia University in the US, the Sabin Center, and which is fed by a large network of international experts who work in this area and who together make sure that this database is up to date and populated. So if you are interested in understanding the breadth of climate change litigation at the moment, this database is a very good research tool to start. I am part of the network myself on behalf of the Netherlands to make sure that the Dutch cases are up to date. So I think it's a good place to start. The picture here on the screen is probably one of the most well-known Dutch cases, also a well-known case internationally, the Urgenda case versus the Netherlands, because it was one of the first cases, not one of the first cases, but an important case worldwide where a court dared to establish that climate change violates human rights and that also governments were obliged to limit their greenhouse gas reductions as a result, faster than they were originally planning to. This judgment has had quite big impact in the Netherlands because it has really led the Dutch government to change its climate policy. This case started in 2013 and was completed to the Supreme Court in 2019, 2020. Because it was one of the early cases, it has also inspired many other climate cases around the world. But I will get back to this in a bit more detail. Importantly, there are now nearly 1,000 cases registered globally. This is minus the US, which has its own separate database. And about 155 of these cases are identified as being based on human rights by now. If we look at litigation in the Netherlands, and I base this on what is there in the climate case chart database so far, which mostly operates along the lines of the definition given by Siti also in her presentation. We see that in the Netherlands there are at the moment 16 climate cases on a wide variety of different topics. In the Netherlands we have quite a few cases also at our Advertising Code Commission about greenwashing advertisements. So KLM saying that it's responsible to fly, and it's environmentally responsible to still fly, even though that's quite difficult to make that statement, or that they will become CO2 neutral in the very near future. Those types of things people complain against. But we also have seen some cases against certain energy infrastructure, if not coal-fired electricity, actually biomass plants. I want to focus a little bit for this presentation on the human rights cases. And this is where we've had two major human rights cases against the Dutch state. One is the one I just mentioned before, Urgenda Foundation, and initially also a large number of citizens against the Dutch state. The citizens were not part of the case anymore after the first instance, because Urgenda realized it could do the case very successfully by itself. And then recently, based on successes in the Netherlands, but also based on successes elsewhere, we've seen a new case started by Greenpeace, Bonaire, and citizens of Bonaire Island, which is one of the islands, Dutch islands in the Caribbean, Bonaire being a municipality of the European part of the kingdom since 2010, where there is a complaint also about people suffering from climate change through the actual effects of climate change and a lack of adaptation efforts. And their complaint is there is a widespread effort to adapt to climate change in the European part of the kingdom, but what about the islands? Do we also not deserve very strong protection against sea level rise, storms, etc.? This case has just started and is pending. There is no judgment on it yet. Then we've also had two key human rights cases against companies. The first one is Milieudefensie versus Royal Dutch Shell, which is a large fossil fuel company based in the Netherlands. There has been one judgment on it so far in the district court, and the ruling in appeal is expected for sometime November this year. In this case also, Milieudefensie as an NGO claimed that Royal Dutch Shell as a fossil fuel company is emitting far too much greenhouse gas emissions so far. And the claim in the court is that Shell has to reduce its emissions quicker, and more specifically, 45% compared to 2010 by 2030, and to be net zero by 2050. Because the complainants say this is absolutely necessary to make sure that the world stays on track to meet the commitments under the Paris Agreement. It follows very much the same type of argument that we have seen in the cases against the state. But in this case, NGOs say it's not just the responsibility of the state, actually. There are also human rights responsibilities of companies directly. And I will explain a little bit more about the legal basis for these cases in a minute, because some of it is quite unique. Again, based on previous successes, the first district court case, but also trends worldwide. This should be actually 2024, not 2014. There has been a new case of milieudefensie also against a financial institution, a bank, for financing fossil fuel companies and the need to stop that. So in the Netherlands, there is all types of litigation on different fronts, and I will explain in a minute as well, mostly by NGOs so far, rather than citizens. So that is maybe also different from the Indonesian context. Then if we look at the climate case chart for Indonesia, we see that there are so far 15 cases listed. Large extent was explained indeed by Siti already. Many cases related to forest fires or damage to forests, mangroves, other types of climate sinks being destroyed and therefore losing capacity to reduce greenhouse gas emissions or to absorb greenhouse gas emissions. These claims may be more or less central to different cases, but they are identified in the case chart as being part of climate litigation. And there are also some actions against coal-fired electricity plants. I want to draw your attention to one key human rights-based case, which was relatively recently launched in Indonesia by a group of youth, also with some adults involved, different generations, which is pending in the National Human Rights Commission of Indonesia. So again, no result yet, but I think the claim of this case is extremely interesting to already study in detail. It is a document of 102 pages, whereby the applicants really try to, in a lot of detail, advance a human rights claim that is also relevant in the Indonesian context. And it contains many different types of claims. That is then what I want to briefly highlight. Maybe some of the unique features of the litigation in the Netherlands and Indonesia, and to see if there is space for mutual learning or mutual inspiration, because that happens a lot in this climate change litigation sphere. Climate change is a global problem, and different litigants are looking towards each other for legal strategies. And some things may not work in another country, but we do see this cross-fertilization of judicial approaches. So first, unique features of the Dutch rights-based cases have been also recognized in the literature. That first of all, there was a very creative use of civil law norms. In our case specifically, a norm that says you cannot commit an illegal act or an unlawful act. And if you do so, you must be responsible to either stop doing that, like an injunction, or you may be obliged to pay damages or whatever it is that the aggrieved party thinks is a good remedy. But you cannot act in an illegal way, in an unlawful way. The problem is the term unlawful act is not defined in the civil law, which means that we need to give it a definition. And the unique interpretive move that is made by Dutch courts and also the plaintiffs is that it might be unlawful for both states and companies to harm the human rights of individual people. So when a court can decide that there is a human rights violation of some sort, we can understand that as an unlawful act against the citizens or against NGOs, environmental NGOs that protect the environment. And we see in the Dutch context that so far the cases that have been brought so far, they have relied on the European Convention on Human Rights, the right to life, the right to private life, family life, and home, and also in the Bonaire case, the people's rights to culture. The other interesting thing is that the interpretation of this open norm, it didn't just happen based on human rights. The Dutch courts have adopted a very international law-friendly approach, whereby they really try to understand what it means to act illegally in the context of climate change by taking into account a broad range of legal norms. So also the Paris Agreement on climate change, also the UN Framework Convention on climate change, also the so-called International Law Commission's articles on state responsibility for wrongful acts, an international document on wrongful acts, but maybe also relevant for the Dutch context, or the International Precautionary Principle. Right, so by including all these norms, the Dutch court was able to decide, so far in all the cases that have been brought, that the Dutch state or that companies have been acting illegally and were obliged to do more than they are doing now. For companies, similarly, the courts have been, in the Shell case, even willing to engage some so-called soft law in this area. So they say that the UN guiding principles on business and human rights, which are very clearly supported by Shell, are also relevant to interpreting these Dutch norms. Finally, cases are mostly brought by NGOs. That's also because we have very liberal standing rules for environmental NGOs. Unique features of the Indonesian youth case, in my opinion. I really am really impressed by this application, I have to say. I think it's potentially one of the most exciting applications out there at the moment, because there are a number of unique features to this case. I think it looks very well argued in the pleadings. It's very extensive. And what I like about it, or what I think is interesting, is that it's brought by citizens from all over Indonesia with different features, different issues with climate change, both young people and somewhat older people. So there is a bit of an intergenerational solidarity there as well. The plaintiffs use the Indonesian constitution and the national law on human rights. And they make a very strong claim, again, similar to Urgenda case, that all of this law must be interpreted in light or in consistency with international human rights law, where there is also a lot of development or a lot of understanding about how climate change violates human rights. And the applicants really invoke all of this international human rights law. The applicants also raise a wide variety of issues for the National Human Rights Commission to deal with. They both ask for better mitigation of climate change. They ask for better adaptation. They also say we need some social protection mechanisms in case we are being struck by climate disaster, for example. How do we recover from that? So I think there are a lot of different interesting things there. And in a way, they also seem to be building upon the previous climate cases that already were done in Indonesia against individual coal-fired plants, for example, or specific energy activities, to try to say this must be regulated better in totality. Finally, I also am really impressed by the sort of diversity of impacts or claims of impacts that the applicants made, including some novel issues that I don't think we have seen so much in other climate cases yet. And then I'm thinking, for example, of how heat waves also decrease the productivity of workers, how sea level rise might be causing specifically coral bleaching, and that also impacts things like tourism and fisheries. And one thing that really has my own interest as well, the increasing attention to mental health effects of climate change, especially on young people. And this is not entirely unique to the Indonesian youth case, but the way that applicants are expressing these mental health effects, I think, is really, really telling. This is maybe, one more slide. I have one more slide, I believe.
Oh, it's just not working anymore.
No worries, thanks. This is the slide I want to end up of, and to maybe also briefly look ahead a bit based on my own research interest at the moment, including some of our colleagues in the Groningen Center for Health Law, David Patterson, who I think is online, but also Monique van Kouwenbergen, who is here in the room. At the moment, we are particularly also investigating how health-related complaints, climate change will affect our health in so many different ways, how these health-related effects can be brought better into climate change litigation, or how health effects are being used as drivers for climate change litigation, both strategically to draw more attention to the issue, but also legally to achieve a better outcome. And then we are particularly interested in how can health evidence be better mobilized in these climate cases? Is that done in a good way already at the moment? Is there room for improvement? Could there be also better cooperation between public health experts and lawyers in that case? And is there more scope to understand the range of physical and both also mental health impacts of climate change and the need for either policy action or legal mobilization? And what we see also there is that especially amongst young people, these mental health effects, this feeling of eco-anxiety may also be driving people to go to court, right? This frustration of the government is not doing enough, companies are not doing enough, and we need to compel them to do more. So there is, I think, a lot to unpack there. This is a bit of the research agenda we have in Groningen at the moment, and I would love to explore more with others in Indonesia to see how we can work together. Thank you.
Yeah, thank you very much for your comprehensive presentation, Marlies. And then I would like to continue the presentations from both our distinguished speakers. So they have been talking about the importance of climate litigation in order to realize the right to a healthy environment. And I would like to open my presentation saying that when corruption is still pervasive, rampant, and systemic, then it will be very difficult to have a good climate litigation and also to realize the right to a healthy environment. Yeah, next. So this is the legal basis for the right to a healthy environment in Indonesia. So we ratified the ICSCR, or in the International Covenant on Economic, Social, and Cultural Rights, through the law number 11 of 2005. And then the right to a healthy environment is also enshrined in Indonesian Constitution. So Indonesian government is under the legal obligation to realize the right to, they don't put it in a like literal the right to a healthy environment, but they put it in the formulation of everyone shall have the right to enjoy a good and healthy environment. And this research is based on my research with CFC, where I studied the right to a healthy environment in ASEAN. And Indonesia is among the countries that have such clear provision in the constitution stating that every Indonesian citizen has the right to a healthy environment. And then this is the domestic law concerning the environmental protection. I think Siti can explain more about this, but I would like to show you that we have a comprehensive set actually about the domestic law concerning the environmental protection. And then next. And then the domestic law concerning anti-corruption. We have a comprehensive set of this. But the question is, can we really implement this in reality? Next. Yes, that's next. Yes. So this brought us to the question upon the implementation of international law, especially international human rights law. In domestic law in Indonesia tends to be problematic sometimes because whether the government will do incorporation or transformation and how to ensure the accountability of the government, these two questions remain unanswered until now. Because Indonesia, from various publications, it's still unclear whether we are a monist or dualist country. When it is very important to, have a strong stance towards international law. So what mostly happened in Indonesia is the government ratified the international treaties, but then sometimes it's kind of slow and difficult to ensure that this international treaty can have a strong domestic law, and when people can really claim these rights upon the court. So this is the challenge that remains until now. And then I would like to show you that there are examples of corruption cases related to the right to a healthy environment to see whether the legal frameworks that we have are adequate to realize the right to a healthy environment. And then there are a lot of case laws concerning corruption in the environmental sector. So I selected two big case laws. The first is in the case of deforestation. So I did my PhD on the topic of corruption as a violation of human rights, but I limited my corruption cases into the right to health and the right to education. So this case fell out. And then when I studied the realization of the right to a healthy environment, I found this case. So this is among the biggest corruption case in Indonesia because this involved the chief of the Constitutional Court. So you can imagine how big is the problem when the chief of Constitutional Court received bribes from the plaintiffs. So when I dig deeper into the case, so the case is about there is an incumbent regent. His name is Hamid Binti, and he was the regent of Gunung Mas. Gunung Mas is located in Borneo. There are a lot of hutan adat, we call it forests, that is managed by indigenous people, and then these forests are very important to the lives of the indigenous people themselves. But the region in Indonesia, they have the authority to grant forest licenses, to open the forest for palm oil plantations and various kind of commercialized activities. So the position of being a region is a very pivotal position, that we have to ensure that every region in Indonesia, they are good, they have integrity, to ensure that all of the laws that we have created can really be implemented. And then the case happened when Akil Mukhtar, he was the chief justice of the Constitutional Court. When he was handling the case of the region of Gunung Mas, the case, it was this region was seeking re-election, but in that re-election he lost, and then he brought the petition to the Constitutional Court, and turned out he paid intermediary to pay the bribe to the Chief Justice of Constitutional Court. And then at the same time, he received the bribe not only from Hamid Binti, the regent of Gunung Mas, but also from other 3 local election disputes. So from other 3 regions looking for re-election. And then this case was handled carefully by the court, and then Akil Mukhtar was given a life sentence, and I think it is quite fair to show that what he did was really serious, because as a Chief Justice of the Constitutional Court, he should be the guardian of justice, not the one who's committing corruption, right? And then in the impacts to the environment, imagine if the petition of Hamid Binti was granted, he would become a regent again. And during his reign, it was shown that Hamid Binti granted forest licenses and permits that led to deforestation and environmental degradation. So this is the corrupt scheme that happened. So local regional candidates who lost the election, sometimes they contested the decision of the election commission through constitutional court mechanism. And then what happened in that case, Chief Justice of the Constitutional Court received bribes from the local and regional regional government candidates who lost the election. And if this corrupt scheme successfully happened, then deforestation continues, because the local or regional candidates incumbent, they won the election dispute through bribery, and they will still do the old pattern. Thankfully, in the case of Hamid Binti and the other 3 candidates, they lost because the corruption scheme was discovered, and then Akil Mukhtar was brought to justice. And then the other example, it's a more recent case. It's about the illegal mining. This case has been trending viral in Indonesia, and this is the case of Harvey Muiz et al. With regard to illegal tin mining corruption. So PT Timah, state-owned tin mining company, turned out they leased smelter to illegal tin mining companies and allowed these companies to mine in the concessions that should be the authority of the PT Timah. And then Harvey Muiz is the main businessman who allegedly orchestrated the whole corrupt scheme. And his role is like a broker. So he connected the owners of illegal tin miners companies to the directors at PT Timah. And then the Attorney General, they are still, they have already begun the proceedings upon this case. And this case involved Harvey Muiz with 3 directors of PT Timah from 2015 to 2022. So it's quite long, a lot of money involved there. And what surprised me is corruption this long, it's just discovered now. So yeah, we can imagine what happened to the environment in Bangka, in the place where this happened. Next. So from all of the cases of corruption that I have studied, this one has the biggest alleged state financial loss, up to 26 billion. Yeah, if we would like to buy pancakes with 26 billions, how much do we get? But the alleged state financial loss is calculated based on the amount of fund that Indonesian government needs to pay to repair the environmental degradation due to illegal tin mining operations. So because illegal tin mining companies operate in that mining sites, because they are illegal, they have no rights and obligations, and it happened for a long time. When they finished, when they thought that there is no tin anymore, they just left the sites open, and it's very dangerous for everyone there. Very dangerous for the indigenous people there. And from the news that I read, there are some when rain comes, and it's very difficult to spot which are the holes. So people can easily fall into that, and fishermen also, they face the most risk, because when they are sailing, then they could fall into these things. And then there is also money laundering happen, and the money laundering disguised as corporate social responsibility. So this is something that we should be aware of. So when we hear corporate social responsibility, we think that it's something good, but turn out the corruptors, they use this scheme to disguise their corrupt money. So Harvey Muiz, he collected the contributions from illegal mining companies and disguised them as corporate social responsibility funds. Thankfully, the Indonesia has this financial action task force. They managed to spot that these transactions are weird, questionable, and then they found out that, oh, this is part of the scheme. So in short, corruption in the environmental sectors, in the case of Harvey Muiz, he's the representative of a business sector. So companies can bribe local or regional leaders, and then deforestation can happen, illegal mining can happen. And then when the election comes, the corruptors, they will try to find a way to maintain their position, to maintain their authority, to keep the corruption going as long as possible. And then what happened in the Akil Mukhtar case, we can see that corruption happened in the judiciary. Climate litigation also relies on a strong judiciary with integrity, right? So when this happen, then it's difficult to have a fair decision reflecting justice. And then if the whole corruption schemes go undiscovered, then what would happen is deforestation and illegal mining continues. And it's very difficult to realize the right to a healthy environment if things still like this. So comes to the recommendations. The first one is a bit classic, cut the cycle by strengthening law enforcement. This is very important, and I think most of the authorities in Indonesia, they are still doing this with a lot of challenges. And I think this is the most important. The second, we have to prevent the conflicts from running in the election again. So in the case of Hamid Binte, by the end of his reign, many like indigenous people, they already protested. Hamid Binte did not do good things, good policy when he was a regent. So many people already spoke out. But you know, when facing with power and money, it's easy to silence these people, right? That's why I think Corruption Eradication Commission, Judicial Authority, they have to find a way to prevent the conflicts from running into the election again. Otherwise, the cycle will continue. And then, in order to make sure that the second recommendation is success, we have to educate the voters to select candidates. I think young people can play great role in this part. We can make the cases viral and ensure that everyone knows that this person committed corruption, and when this person tried to get re-election, yeah, we should, if he managed to be candidate, then we should not vote for them. It's within our power, I think. And then these are the criteria for the good candidates: never been convicted for corruption, have strong anti-corruption commitment, and also comply with anti-corruption mechanism like reporting annual wealth. Because from their annual wealth, you can really see whether this person has healthy, track records or not. Because sometimes after someone sit in an official position, their wealth inflated. This is something that we should aware. But we have to see also whether he or she receive the wealth based on the legal way or illegal way. And then increase the vigilance. For example, check the forest and mining permits issued during the tenure of local or regional leaders. If the number does not balance, like the case of Hamid Binte, so during his reign, the amount of forest permits, it was increased a lot. So I think this is something that we can do, what academia can also do to support the judicial authorities to have more evidence-based policy. And I think this is a good point for collaboration between Indonesia and the Netherlands. And then this is the end of my presentation. Thank you very much. Before we come to the Q&A session, I would like to discuss with Marlies and Siti that what kind of potential collaborations that can be done between Indonesia and the Netherlands. I will start. Take, for example, PhD studies. I think many PhD students from Indonesia can learn good practices from the Netherlands. And also researchers from the Netherlands can also learn about the problems in Indonesia and the good practices in Indonesia. What about you, Marlies? Can you please come to the front? And also, can we please show Siti?
Okay. Yeah.
Yes.
Great. Yes, Ratna, I would fully agree. So there is a lot of space to work together as researchers from the different institutions, but also to work together in supervision of PhDs. I have another PhD in the room here, Alt Mano, who is researching energy regulations, and to see how they are sufficient or working or not working towards meeting Indonesia's climate objectives. But I also think that there is space, and I think particularly legal sciences allow very well for that, is to do these types of more translational cooperation activities. Things also like mutual training, mutual learning processes of different kinds. I have been myself involved in some trainings, for example, also to judges in Chile that wanted to know more about the Agenda case, like I said, which was a landmark case, but it can also go the other way around. I was in a conference 2 weeks ago where there was a speaker on behalf of the National Human Rights Commission of Indonesia, Mr. Hartono, was explaining all their great work generally on human rights and energy transition, which I think human rights institutions around the world can learn a lot from, including the Dutch National Human Rights Institute. So I think there's a lot of space to also work together with stakeholders and to share experiences there.
Thank you very much, Marlis. Siti, would you like to say something about the prospects for collaboration?
Yes, of course. I think there are two things that I think that's important that we can learn from Netherlands. The first is for judge, and the second is for maybe for civil society or for academics. For the judge, that I agree with Marilis that maybe we can learn how the Dutch judges when they adjudicate the climate cases against, and this is complex issue. Maybe we have to learn and we have to get some training maybe for our judges, for Indonesian judges, how when they face or adjudicated the complex environmental issue like climate change. And for the civil society or for the research, maybe we also need to learn how we again we connect um, our policy or regulation evaluation to national determination contribution when our Indonesian government already decide its commitment to reduce emission in the certain point by certain year, like Indonesia targeting 31% by 2030 and even more ambitious target of net zero emission by 2060. But we try to, it's not only on paper, but how we can evaluate our the existing policy and regulation that's already really achieved to that goal. So maybe we have to learn it from Netherlands, I think. Yeah, that's all for me.
Okay, thank you very much, Siti. Yeah, I agree with Siti. I think we can, in the Indonesia and Netherlands, can cooperate to provide trainings for judges. Take for example, because of the monism dualism is still unclear in Indonesia, so I think we can make it clearer that way, and also to mainstream international law, international standards into the domestic law and practices. Okay, now we are going to answer the questions. I would like to open the Q&A sessions, but because of the time, I think we can only make it one round with 3 questions. I have seen the questions on the chat. So the first is to me, how to calculate the environmental losses with the losses from PT Timah. I think TIN means Timah. And what are the actions? So as far as I know, the way the prosecutors calculated the loss of the state funds, they ask for the calculation from the related ministries, from the environmental ministry, and then from the prosecutors themselves. And $26 billion is actually the loss of the state funds with regard to the amount of funds that Indonesia has to pay to repair the whole environmental damages. That's why it becomes a lot, because to repair environmental damages, it takes a long time, takes a lot of resources. But in regular corruption cases, the take for example embezzlement cases, usually the government will calculate based on the amount of money that was embezzled. Like in health and education sectors, take for example, the school deserves 100 million rupiah, but the corruptors took 90 million. Then they calculate the losses based on that. And also with the financial action task force, everything is clearer that way. And then the next question, it's for 3 of us. I think I would like to let Siti or Marlis answer. Siti, would you like to answer this, or Marlis?
Maybe City first?
Maybe Siti first.
Yeah, because the the question is what is the most effective way to enforce environmental law in Indonesia among the recommendation given? Okay. Well, when we talk about what is the most effective way to enforce environmental law, I think we need to start think. But Indonesia is already take an effort of it. Like environmental law is not only by command and control. I mean that the government, the officer supervisions of the people, and if there is some unlawful action, then the officers give a punishment. I mean, that's the classic way to enforce the law. But about the environmental law, we have to think about the system. How if we entering the market system means that if with the incentive and disincentive system, I mean, if you sell or buy some unsustainable product, you have to pay some with more pricey price, for example, or with more expensive one. But if you choose or produce a sustainable product, considered a more sustainable product, then you will gain benefit that you have can buy it with a cheaper price, for example. So I think we need to develop that system that people feel that it will be more advantageous if we choose a sustainable action rather than unsustainable action. So I think that's the more effective way to enforce how our action, our habit, more sustainable and more pro for environment, rather than the government, the officer make some supervision, and if there's an unlawful action, then they give a punishment. I think that's difficult, as our officers still like bribery or corruption is still exists in many sector of government, as Ratna told to us. So I think the system or the market system is would be more effective, I think.
I would like you answer this.
Yeah, thank you. Yeah, that's a very good question. Maybe from a more human rights law perspective, I could say that if we talk about the enforcement of environmental law through courts and through rights-based cases, the approach of the Dutch courts or also European courts have been that, first of all, yes, there is a balance of different interests, but human rights provide a sort of bottom line sometimes below which you cannot go. So in the Netherlands and also in other courts have played a role in enforcing that bottom line. So saying yes to the state, you have a lot of space, discretion to make your policies and to decide which interest to protect, but you can never breach an essential human rights interest. So when you do that, a court has a role to enforce, for example, environmental laws that help protect a right to a healthy environment or a right to life or another human right that your constitution has. So that is one answer, to say that human rights provide a bottom line. But beyond that, states have also provided indeed discretion to states to find a way to balance these interests. And there have also been court cases where the court said, well, we feel uncomfortable deciding whether or not there is a violation specifically, but we do see that you have failed to comply with your obligation to balance all the interests carefully. So maybe indigenous peoples were forgotten or some vulnerable community was forgotten. And then the court can send the government back to the drawing board and say, you need to show that the process of public participation, for example, has been done better. So that forces the state to potentially do better. But there are, of course, also realistic concerns explained by Ratna about public participation processes or legal processes being corrupted in some way. And that is a different type of challenge. Yeah.
Yeah, thank you so much, Siti and Marlies. And I think, I hope we have answered Fanny's question. And then there is one question from Peter. Can the litigation approach also be extended to the emerging market of carbon credit? I'll let Marlies answer this.
Yeah, thanks, Peter. That's a very good question. Also a difficult question. I don't have a full answer to you. What we do see in this climate case chart that is published by Columbia University is that there have been many cases by companies complaining about the allocation of carbon credits to them and whether or not this was sufficient or wrong, etc. I am not personally aware, but that doesn't mean that they don't exist, of cases where people have brought a case to complain about carbon credit systems in general. I do know that in the Dutch cases against KLM, for example, there have been complaints that the carbon offsetting mechanisms, so I can make a small donation to pay for my seat on the flight and then KLM plants a tree somewhere, that those types of schemes are being challenged for not delivering on the promises that they make and therefore not helping to combat climate change enough. So we do see that cases exist against these more economic mechanisms of climate change management, but I'm not specifically aware of the carbon credit system that I think you probably have in mind. Yeah. If you're interested, please be in touch. Yeah.
Thank you so much, Marlies. Thank you, Peter. I hope that answer your question. And then there is another, I think it's more like a comment from Brian. So yeah, about collaboration on energy transition needs to involve all of the stakeholders. We three of us agree with this completely. And yeah, it's a good note. And then because of the time limitation, we cannot open the second round of the Q&A. Please feel free to send us emails. So I hope that the committee circulate our presentation and our emails there. So please keep in touch. We would love to hear from you and collaborate with you. And I will, as the moderator, I would like to close the session. I think my distinguished panelists, Siti and Marlies, for a wonderful contribution. So thank you very much. Goodbye.